Hi, everybody. If we could get everybody sitting down, that would be great. Thanks. So we'll just wait for these guys here. Thank you, everybody. I hope everybody enjoyed this morning. We have more interesting discussion and debate, no doubt, to have this afternoon. But before getting into the meat of this afternoon's program, we're very fortunate to have the Dean of Social Sciences here, Marcel Maret, who's here to say a few words of welcome. It's nice that we have people from around the world, really, that have joined us. So we thought it would be nice for him to join us to say a few words of welcome. So I'd like to introduce Dean Marcel Maret.
Thank you very much, Stephen. You're participating in a very important symposium, so I don't want to take too much of your time, but I would like certainly take this opportunity to welcome everyone to the University of Ottawa. I understand that this symposium marks the 20th anniversary of the Westray mine disasters, and you're here to explores the growing interest here and abroad, international interest in corporate criminal liability. And I think it's a fantastic opportunity to examine issues, very important issues relating to workplace safety, corporate responsibility, and law reform. So I'm the Dean of the Faculty of Social Sciences. For your information, we have about 10,000 students, 260 professors, so it's a huge faculty. We have a brand new building, so I hope the next time we'll be able to welcome you at the new building. We of course have a wide array of programs and research activities, but we like to be rigorous, but also relevant. And this is why we are not afraid, and we encourage multidisciplinary or interdisciplinary research or conference activity and connected with the community. So this is why this conference or this symposium fits very well what we like to do. So as the Dean of the faculty, I'm particularly pleased that Westray Plus 20 provides an opportunity to discuss and debate issues of corporate criminal negligence in a multidisciplinary environment, bringing together academics from here and elsewhere, legal practitioners, policymakers, regulators, victims, students, and labor union representatives to examine an important social issue. The diversity of ideas and opinions expressed at these symposiums reflects the faculty's commitment to fostering innovative research and working with the community in developing solutions to important social issues and public policies. I congratulate everyone for being here today, for marking the 20th anniversary of the Westray mine disasters, and for exploring ways of making workplace everywhere safer. So I'm pleased on behalf of the faculty to be a partner of this event, partner with two other faculties of the University of Ottawa, Faculty of Common Law and Faculty of Civil Law, as well partners coming from the United Steelworkers, the Canadian Labour Congress, and the Westray Families Group. So I wish you much success in this, in your important symposium. Thank you very much.
Me again. I'd just like to take this opportunity to thank everyone for being equally obedient and coming back after lunch as you were this morning with time. Well done, well done. It's my pleasure to introduce Harry Glasvik. He's a professor emeritus and senior scholar with Osgoode Hall Law School at York University, an adjunct professor at Victoria University, and has taught at the universities of Melbourne and Monash in Australia and the University of Western Ontario in Canada. From 1974 to 1996, Harry was a professor at Osgoode Hall Law School. Since retirement, he spent 6 months of the year as a visitor of Victoria University, and he's written books on Australian labour law and Australian evidence law, on Canadian labour law, and Canadian evidence law, as well as more than 120 articles on tort law, labour law, bills of rights, legal education, corporate law, corporate criminality, corporate social responsibility, and occupational health and safety. His last book, and I will point out his 10th book, was Wealth by Stealth, Corporate Crime, Corporate Law, and the Perversion of Democracy. And so I'd just like everyone to give a warm welcome to Harry Glasvik.
Thank you. It's a pleasure to be here and honored to be invited to participate in something as sad as 20 years since Westray. It is sad, and much of what I wanted to say when I was asked to come and speak has already been said. There isn't much to say, you know, it's all pretty obvious. We have a tragedy, we react, and everything's exactly the same. I finished. That's what we do each time. Stephen Bittel talked about the wait and how long it took to get his legislation, Bill C-45. Steve Toombs talked about, I think it took slightly longer in England to get slightly worse legislation. Now, what is the matter? What is the matter? Well, I think it's an old story. If you have a bad theory, you get bad practice. And we theorize very badly about regulation of health and safety, indeed regulation about most things, but health and safety, which is what matters here and to me, in fact. Very, very briefly, because we haven't got much time, we say that we love the Robbins model. I don't know why, but we do. And the idea is very simple. It's very attractive. The idea is we'll regulate by having information, gathering the information by some regulator, who will then set standards and practices with the help of the parties who are going to be regulated. So we've got a consensus going on as we're doing that. And then we have that consensus, and then the regulator sets out to help the parties give life to the standards and practices they've established. They set up institutions, as well as education, but institutions like, I don't know, joint health and safety mechanism, work hazardous materials, information data to be spread around, and monitoring, and perhaps enforcement if people still don't comply. But basically, once we've done all that, we can trust the parties who have a mutual interest in making the place safe. Having done that, we rest on our laurels. That's all we have to do. We shouldn't intervene. We should only enforce those established practices and standards externally, by external force, occasionally. That's all. Of course, we accept that there will still be problems. There is a steady drip of blood. There is a steady procession towards hospitals and other medical care facilities. And there are funeral processions. And they continue and persist. But we say, we've done all we can do, and we're trying to do better. Let's help them. The great success of this model is that it normalizes, it naturalizes an unacceptable toll in the workplace. And there are always nagging doubts, aren't there? That maybe it isn't working. Maybe it just isn't working all that well. And you can see where the nagging doubts come from, because although I say that there are still some injuries and illnesses and deaths, remember that the bleeding is done, the illness is inflicted, and the deaths are incurred by workers and no one else. One of the parties hurts are normalized. Not the other. One. Now you think that people would say, this is not a good idea. This is not how it should be. Have they really agreed to that? But most of the time it's a success. Most of the time we don't think that's wrong. It's when something happens. Like Westray. We have many of these, by the way. When something like that happens, then all of a sudden says, oh my God. And there are two sort of, there is a scenario. It's a recurrent scenario. Everything is recurrent. That's the wisdom of age speaking to you. One, people express sympathy for the victims and their dependents. There's anger and shock. Shock because all of a sudden the public realizes all this regulation we have, but life is actually much riskier than we thought. And then the anger, because the regulator was supposed to take care of all that. We've done all that. We should have got rid of all these problems. Now the elites have to jump into place. And you get another scenario. Senior people walk around the mine, hard hats on, looking very serious. They regret all this. This is awful. And we'll do better. We'll learn from this and make our urban system work better, is what they tell us. We'll do. And this is another point I want to make. It's a little point, perhaps my first point to make. We only get standards and practices established when there is a sufficient of a body count. We need people to be hurt, be diseased, and die before we do something. We start off with the notion that there is nothing to do. That's bad theory. So we're going to do better. Lessons will be learned. And we have to do that. That may not satisfy the public, because now they're shocked, they're angry. Where were you? So, and they might even say, well, look, if a drunk goes out in a car and kills somebody, he's prosecuted. He was heedless, reckless, like this corporation was, of human life. Or if a drug addict goes and breaks in somewhere and does harm because he needs to feed his drug habit, like the employer does, we prosecute. Where a man can't control his lust and assaults a woman because he needs to do that, we prosecute him. But here we say, no, and the public might get angry. So the regulator has to react because it's suggesting that the rule of law doesn't apply. It's not even-handed after all. It may be that we favor certain kind of sectors of our community, like corporations, who are the main component part of our economic activities. And maybe even the system on which we rely, that is the private accumulation of socially produced wealth to ensure welfare for all of us, might come under question. So we have to react. That brings us to the Bill 645. That's what it was. I think Andrew King said that this morning in his comment in question. Show our good faith, that we really mean it. And so we reacted. And we got this bill. There are two ways of responding, by and large, in our countries. Our countries, for these purposes, being, for me, Australia, Canada, UK. We've responded in two ways. One, we say, well, really, the public is stupid. It doesn't understand corporate law and criminal law. Criminal law is about individuals tearing away at the moral values of our society, and therefore, because they've individually done that with their own sovereign free will, we punish them. They're bad apples. That can't apply to corporations, because although we pretend they're individuals, they're not. Now notice this, they say that then. They don't normally say that, not when they enter into a contract. They say it then. And they say, they're not really individuals, or not like us, so we have to find somebody who can think and act for them We have the identification doctrine. I won't bore you with that. You got a whole thing about finding the guiding mind and will, and if he's responsible, the corporations. That's too difficult. And anyhow, the penalties that we apply in criminal law don't really apply properly to corporations. So maybe there are technical problems. The public doesn't understand. We're not biased. We're not biased in favor of this group. It's merely a technical problem. So we can fix the technical problem. And we got new identification doctrine, Bill C-45. Slightly improved identification doctrine. The other response has been, the corporation is different. It is more than the sum of its parts. It has a dynamic entity of its own. Now that's breathtaking in corporate law, by the way. Because if that is so, none of corporate law would work. But in criminology, we say that. And for policy reasons, we sometimes say that. And so we might have that. It's a dynamic entity of its own right, and therefore the act was terrible. It offends our shared moral values. That is, it's criminal. Criminal law should apply, but differently. Differently. And we're going to make them responsible for their operation, for their system, for their culture, for their mindset. Choose your own word. And Canada, being Canada, is improved the identification doctrine a bit, and it's gone a little bit of the way towards this model as well. Only a little bit towards the way. And we heard that in one of the participants this morning, Ken Jules suggested that. Yeah, I'll leave that. I'm not going to talk about the Act. It's got technical problems and technical flaws, but that's like any statute. What I want to talk about is the three aspects which strike me as being worth noting. All about this bad theory stuff. One of the reasons it isn't applied, we heard a lot about that this morning, about the technical difficulties. Well, in order to be responsible under this statute, especially under the negligence aspect of this Bill C-45, you need to find a breach of a duty, and the content of which is a health and safety duty. So if you look at that, you look to the health and safety provisions. They're administered by provincial jurisdictions, and if you want to prosecute, you've got to go to the Attorney General Department. In Canada, criminal law is federal jurisdiction, of course, and the Attorney General of the provinces look after that too. We know for years we've hardly had any prosecution of health and safety provisions through this Attorney General mechanism. What makes us think that the Attorney Generals will now say, oh, we're really keen to prosecute more draconically under Bill C-45? What makes us think that that was even plausible? And what's worse about that is that in some jurisdictions, I don't know whether it's true of all jurisdictions, because you can tell by my haircut that I'm not up to date. But you know, in Ontario, for instance, the Attorney General places some of its lawyers, Crown lawyers, in the Ministry of Labour, who've made all those decisions about health and safety enforcement in the first place, and they're going to be the same guys that is they've inculcated this whole Robens model, let's not enforce, and they're now being asked to recommend real enforcement. How likely is that? So what we get is sort of horse trading. We talk about human lives each time, remember? I don't have to remind this audience. We get horse trading. The Attorney General will say, well, I'm going to prosecute you under Bill C-45 unless you, of course, if you want to plead guilty under the Health and Safety Act and make it easy for us, go, well, let's do that. Or vice versa. They go to a senior manager, the new guiding mind and will, however defined, and say, we got you. And the guy says, no, not me. Get it. Remember, you can't see the damn thing, the corporation. I'll get it to plead guilty. And you can fine me a little under health safety provision if you're so minded. That's what happened in Metron. I heard somebody say this morning how serious that was for the employers. Well, in Metron, a company that behaved awfully, people got killed awfully. The president of the company pleaded guilty to health and safety provisions, and paid a hefty fine. The corporation pleaded guilty under Bill C-45 and paid a risible fine, which is on appeal at the moment. And the only guy on the hook is a lowly supervisor who is still being prosecuted. This is not a very interesting system, is it really, to advance the cause? And remember the difficulty for the attorney generals and their crown officers. Health and safety provisions are easy to enforce, comparatively. All you got to do is find a breach. This act is a criminal act, so therefore requires, beyond a reasonable doubt, proof of all the elements that people engage in gross dereliction of duty, and that other people fail to take reasonable precautions to prevent that. That's not easy, especially if the employer digs in its heels. So what does that say? Is Bill C-45 useless? No. What says two things. One, it may advance the course of health and safety regulation because the Robens model, because people are afraid of Bill C-45 and therefore put up better due diligence systems within their operations. It might do that. And the apprehension about that might cause employers to behave better and set up better systems of operation. It might do that. And I have no way of knowing whether it does or not. I have no evidence one way or the other. I do know, however, that the rate of fatality is exactly the same as it was before Bill C-45 came into being. It's still 2.78 workers die every day in Canada on the job. Now, I don't know whether that statistic means anything or not. I'm not good on methodology. But it is arresting. The other thing it means is that Bill C-45, as it integrates and makes the regulation system work better, has the same aims as the regulation system, which is to lead to better self-management of risk inside the workplace. And somebody mentioned that this morning, I think it was Stephen Biddle, not about elimination of risk, about managing it. That brings me to two other points. Have I got two more time? One is that this management of risk ought to have some bite if it took into account what causes the risk in the first place. Now, one of the most interesting things about this bill is that it's not aimed at corporations per se. It's aimed at organizations. Identified as a public body, I actually wrote it down because I couldn't believe it. Public body, society, company, firm, partnership, trade union, or municipality, any association created for a common purpose and has an operational structure and holds itself out to the public as an association of persons. Any damn group whatsoever, whether or not organized for profit. Profit has disappeared as a cause of the problem. The bill relies on organizational theory. Now, this is very funny. Remember what this is. This arises out of Westray, a truly rogue corporation for profit, where the profit motive made the place stink to high heaven. It's not important. It's just another factor in production, is the message of the bill. It's an extraordinary thing. So, all production entails risk, is what the bill is saying. It doesn't matter why it's done. But it makes a huge difference, doesn't it? If you produce for profit, you make a decision as well to own your private, to get your private wealth invested. In what? For how long? With what equipment? With what tools? With what kind of skills you will need? And so on and so forth. It's called business planning. If you do all that, you do it to make profit, you will do it differently than if you're producing for needs or for cooperation. And you will consult different people and consider different people's interests differently. That's obvious. At the table, in the bargaining for reasonable practices and standards, the profit criterion is just another criterion. That's why so many of our statutes in all our jurisdictions talk about take such precautions as are reasonably practicable, which means, of course, reasonable to profit. So we've neutered the corporation for profit by the bill. That's a terrible flaw in the thing. That brings me to the final point. You thought I'd never get there. The corporations do produce for other people, of course. They produce for shareholders. That's how they excuse everything. Our bottom line means to provide for the shareholders. We must produce for shareholders. And shareholders, of course, are a privileged class. First time I've used this word, but not the last time, I promise. They're privileged in the following way. They put some money into the corporation, which instantly becomes the corporate property. For that, you want to know why a red-blooded capitalist gives his money to another person, because that's what the corporation is, right? Another separate person. Why would he give up his money? Never gives me any. Why does he give to the corporation? Because he gets a deal. A legal deal beyond belief. One, he gets a right to profits, if there are any made, according to the share of his contribution to this equity capital. He gets a right to vote. Watch my lips. He gets a right to vote. Again, according to the share of his contribution, not because he's one person, because how many dollars he's put in. Gets a right to vote for the directors of this entity, the corporation, which now has property, deploys it, and kills workers. Perhaps. And the directors appoint managers, and the managers hire workers, who, by the way, in this list of hierarchy, are the only people who work. And not only that, their liability is limited. That is, if things go pear-shaped, they're not responsible except for what their investment might be in that corporation. Their personal yachts are safe. Unlike you and me, when we set up a business and lose and owe monies, our house is up for grabs. It's a good deal. Limited liability. But not only that, it gets worse and worse. Because the corporation is a separate person. Now, I want you to see the corporation right before your eyes. Here it is. Because the corporation is a separate person, it did whatever was wrong. It owes the money, whatever is owed. So the shareholder, a separate person, is not responsible at all. Not only have they got limited liability, they have complete legal immunity for the acts done on their behalf. Is there something wrong with this picture? What workers need to do, I believe, is to make, how much time have I got? 2 minutes? I'll take 5. It's called bargaining. They need to make profits, the making of profits, the central problem. Only then are we going to get the kind of preventive mechanisms that we need. There are many ways of doing this. You can do it by guerrilla tactics, which I advocate, of course. I don't like fighting much. I'm little. Right? I don't want to punch up. But guerrilla tactics, for instance, every common law contract or every collective agreement has what is called the managerial rights clause, residual power for the management. That is, what the workers haven't won at the bargaining table, the manager can do with as it likes. Called the prerogative of management clause often. Prerogative, of course, I have to look it up, I'm a foreigner. Prerogative means the divine right of kings. Why not let us call that clause whenever we bargain, whenever you go out with your workers and want to bargain, why not let's ask them to call it the employer's right to limit workers' rights clause? Because that's what it is. You won't get it, but it's costless. You go back to the worker and say, they want the right to be able to control you. Secondly, you can do that with the health and safety clauses in any agreement. It's good. Health and safety clause, they usually know better than the Occupational Health and Safety Act. But the health and safety clauses are in there. Let's call them limitations on the employer's right to maim and kill. That's what they are. Similarly with joint health and safety, I can go on. I can give you thousands of examples because that's what I do. I play with these things. More importantly, we want to go to the nub of the problem, and this is my last minute. Why don't we make those coupon clippers criminally responsible? Why don't we make the shareholders criminally responsible? And there are legal arguments to do so. We do this in many spheres. Employers are vicariously liable for their workers because they control. It is fair in a liberal economy because you've created a risk and because they have money. We do it when a church and a church functionary has done something ugly. The church may be able to. When a tavern licensee sends people out drunk and so on, we hold them responsible for creating a risk in the world. We do this in many places. The Americans have a super fund in which they hold creditors, lenders to people who have created a waste mess. Personally responsible. And the related employer activities under our various Labor Relations Act. People in the group, that is shareholders in the group, are responsible for the others. We recognize this principle everywhere except here. There's no reason. The reason then becomes practical. You can't find them. And all of us are shareholders. You know, we've all got pension funds and things like that. We're all shareholders. Well, that's just not true. Most of us are pension holders like me. I have no idea what my shares are. I'm sure that my insurance company, my York University holds pension funds in various corporations that are doing terrible things. But it's a compulsory saving for me. It's because my society won't provide me with a social welfare system that I put my money in there. I am saving that way. I'm not investing. I'm saving. It's the active investor we talk about. And then we say, but there are so many of them. Every company has thousands of them. That's untrue. The only two countries in which that's partially true are the UK and the US. And getting less so every day. In Canada, it's hardly ever true. And that's where I'll finish. I'll just give you a couple of numbers to think about. You could pretend that I've actually prepared for this. I can take any numbers. There are many. This is my current work, by the way, so it's work in progress. But here is something to go on with. On the Financial Post 500 list of big corporations in Canada, 246 public firms out of those 500. 53, in fact, have a diffuse shareholding. That is, it would be hard to find a shareholder who controls the operation. You can add it up. After that, nearly 200 of them have a controlling shareholder who holds at least 20%, and the average is 50% of all the equity in that corporation. Don't tell me that you couldn't make him do the corporation what he wants. Because he does that every day. Every day. He appoints a director. He appoints a manager. He changes policy. He sells assets. He does the person. And we know it. We walk on the street and say, that's so-and-so's company. We have no problem with that. Only in law do we have a problem. Of the other 250 corporations in that Financial Post, they're all private. Again, they're controlled by 2 or 3 people or a family. We could do it. Let us do it. Thank you.
All right, so is this working? It is. So we have a good 20 minutes for comments and questions. I fooled you. I knew you were going to. I'd like to, I see one hand up, Pat Van Horn, but I'd like to invite people to ask questions, but also to comment and try to draw some links between the presentations we've heard and what we're trying to achieve. So, Pat, please.
Well, it's obvious that there's a lot of contradictions in what we're hearing today. And the only question that I have, and, you know, okay, let's do it. But, Professor Glasbeek, how?
Well, thank you. I always like that question. What would you do? Well, it means that I've won some agreement. Otherwise, you wouldn't bother to ask the question. How could we do it? Well, it's fairly simple. Legally, you make the argument that we live in a, according to the law, the whole idea of this, central to my idea is to accept the verity of capitalism today, which is that it operates under a supposed liberal philosophy in political terms and a liberal philosophy in economic terms under its market principles. That kind of capitalism is supposed to show adherence for individual sovereignty and responsibility taking. That if an individual can take whatever action he or she pleases, with limits, of course, because all other individuals are doing the same thing, that whatever benefits that individual gains from those activities are his or hers to keep, and whatever costs he or she inflicts on others is for him or her to make up. That is the basic premise of the whole system. That's why we always talk about individual responsibility. That's why criminologists are continuously talking about the risk society. That's what we do. What I'm saying here is that people who actually are in a position to control, and perhaps I did cut it very short, of course, but there is a bit more thought to that idea of making shareholders responsible. When a shareholder gets to a particular level of shareholding in a publicly traded corporation, usually 20% in most of our jurisdictions, that shareholder in the corporation has to notify the investment markets. And the assumption, of course, is that that is because a new controlling influence will be felt in the corporation when a person reaches that level. And that therefore the corporation may change direction. And that therefore its financial returns might well be different. Its practices might well be different. That is, the system itself acknowledges that some people have power to influence the daily events within the corporation. Not just because they're a shareholder, but because they're a shareholder who have a considerable heft and weight in the place. Add to that, whenever there's a merger or a takeover, and if there is a large shareholder, that large shareholder's decision as to whether to say yay or nay will influence everybody in that market. And everybody will have to be notified, and information will have to be given about that. Again, we have numerous, and I won't go through them all, I've got long lists of these. There are numerous indications that we accept that as a given, that despite all our talk about corporations being diffusely held, we know that some people are capable of controlling them and frequently do. So I say this, given these two premises, one, liberal society, liberal market ideology, which underpins capitalism. The other one, the acknowledgement that in fact that corporations can be controlled by one or more or several people. Why not make them responsible for what goes on in the corporations by just simply laying charges against them? As if they were, for instance, representatives or senior officers under Bill C-45. And by the way, just for your amusement, to show you that I was a lawyer once, although I usually apologize for that. The definition of representative in Bill C-45, beg your pardon, in Bill C-45 includes workers, employees, on one level, so employees can be made responsible as party to the offenses. And it's got a very strange word in there, member. Member. I am almost certain that the drafters were thinking of members of an organization. Remember that difference between organization and corporation for profit? But it happens to be in there. Now, the only person who is a member of the corporation is the shareholder. So why not treat that seriously if he's a controlling shareholder? So my answer then may be unsatisfactory, but it has several points. One, it fits within the existing paradigm of legitimation for capitalism, quite clearly. Two, you can identify such people, and people like that are frequently identified for other purposes. And three, it makes sense within the definitions that we have in Bill C-45 about somebody being a party by aiding and abetting or failing to take reasonable steps to prevent harm. I'm talking too long on this, but that's what I really want to say to you all along. If I'm a lawyer, if you can imagine that, in one of these blue ribbon firms, in my head they're all called Tory, 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 and Tory. And I'm a member, and I represent a client who has, I don't know, a 15% share of the shares in Corporation X. And I hear on the street that some creepy guy, probably from China, is buying shares in that corporation and claiming up to 15% himself. It is my duty to go to my client and say to him, look, this is what's happening. Do you want me to take any action about that? Because it threatens your position of control. So that it's not true the shareholder is not interested in what goes on inside the corporation. It is that we don't make him interested in the right things. We can make him interested in health and safety by charging him with a duty to do so. So that's the unsatisfactory answer, but that's it.
Thank you. We have time for one more question, but I see two people standing up, so you can ask a question, but I'll ask that you ask them consecutively, and then Professor will respond to both at the same time. So please.
Okay, I'm trying to and summarize this, but obviously this whole question about how you hold a corporation to account has been going on for a very long time, and it all has to do with how you define what a corporation is. But as you know, and many in this room will know, there's a huge battle going on in the States right now called Kiobel before the Supreme Court, where there was an opportunity there to at least hold corporations to account for human rights abuses perpetrated overseas, and that may now be threatened. And so I guess the question I have is, how does the arguments that you've been making here today relate to that battle going on there now to make sure that Kiobel, that Shell is not successful, and that avenue of holding corporations to account through the Alien Torts Claims Act is maintained? Just to sort of pull the two things together for me. Thank you.
And second question, s'il vous plaît, Jean.
Do you have this translating gizmo, or I'll go in English?
I can do that, yeah.
Okay. I was just listening to your last answer, and I was thinking, well, Merci, Marie. Donc, j'écoutais votre.
I was listening to your last answer. Now I hear the interpreting better. What you were suggesting, to go to the stakeholders of corporations, and I think that we can use the examples of activists in other occupational health and safety actors. There are the campaigns against large manufacturers with child labor, environmental conditions. Those activists very often bought just one share in the company, and it allowed them to go to the shareholders' meetings and to come into the public eye a lot in a stronger way. That's just a comment that I had.
Thank you both. The first question is really a question about how romantic I am. What you're really saying is that the corporate sector, especially in the United States, is in the ascendancy. So it's going to be very hard to actually make them more responsible, the actors more responsible than they have been in the past. And of course I accept that, because I think they are in the ascendancy at the moment. But not completely, but that's true of all change, right? You want radical change precisely because the existing system is so well entrenched that it's doing harm. So any kind of suggestion that you really want to challenge the nature of the system will be met initially with, I guess, derision, and then with very stiff resistance, and may very well fail. Having got that caveat out of the way, it's not all that bleak. It's also true that in the United States, at the same moment, and this is one of the things, by the way, that I had in my head when I was talking about the strange nature of Bill C-45 when it speaks about organizations, not just corporations for profit. What is going on? There are two separate streams of change occurring in the United States at the same time as we have this attack on the Alien Torts Act of which you were speaking. One is that there is a rather solid movement, not by no means sweeping movement, but a solid movement amongst many counties and many municipalities to get their states to pass legislation, to abolish the right to have corporate personhood in the United States. That's happened in nearly, I think, so now we're talking about over 14 states. So there is a counter impulse as well. The second point of that nature, but not as dramatic, I think, it's actually trying to save the corporation from what is a lot of ill will felt by the public towards the corporation as an entity, is that there's various state legislatures, nine in all, have made it possible for corporations to register as benefit corporations. That is, that they can decide for themselves that they will have certain beneficial objectives, not just profit objectives. And if they so decide to do so, they can pick anything they like: environmental pollution, health and safety for workers, more communitarian recreational parks. It's their choice. Then the duties of the directors of that corporation will now be judged and evaluated by their own objectives so registered. Now, it's very limited because it follows that nobody who is actually adversely affected by the failure of that duty, say it was something about the environment, no environmentalist can come forward and prosecute the directors. That right is specifically forbidden. But it is a notion that the corporation should look after more than its profit-making holders, the shareholders, that's beginning to permeate. So there are slight counter-movements, and whether or not they take hold, my suggestions are also part of that scene, as well as the scene of the corporation rampant and triumphant everywhere. I don't think it actually the fact that it is difficult doesn't go to the argument that I'm offering here. It's a very limited argument. Remember, I prefaced it by saying what we want to do is to get workers to understand that profit is the problem. It is not that we will succeed so much with these tactics, but that employing those tactics will raise awareness. And here I might say, you have some material there on the table from Europe, that's come out of Europe recently. In Europe, where a corporation has a different kind of standing, different kind of legal position, but capitalism has the same hold, there have been recent prosecutions of shareholders, successfully so. So it's not crazy within capitalism to even talk about this. It is possible. It seems impossible to us because we've been taught it's impossible. And for workers to understand that, I think, is a very important thing. The second point, which was really a comment, I take it, saying that while it's true, but truly minor shareholders, holding a share may be useful because you can bring things up at annual general meetings and say this corporation is being a thug and it should do better in the future. And that is true. All I can point to is statistics. That is done, occasionally successful, mostly highly unsuccessful. Activist shareholders, for the most part, and these are the numbers, I won't weary you with them, but overwhelmingly, when shareholders take activities against their directors and their executives and against the corporation, is because they've paid themselves too much. And the corporation hasn't made that much money this year, affecting them as shareholders. That's most of it. So although we have some successes with that, and again, it's symbolically useful, it's on the margins.
So unfortunately, that's all the time that we have for now, but I'd like everyone to give another round of applause for Professor Foster. And as my colleague Stephen makes his way up here, I just wanted to mention, because Harry had said so, that we do have a document table sort of in the center of the room. I'm pointing to it now, where there's a variety of materials, both from our speakers and some of the sponsoring organizations. So if everyone has a point today, please stop by and take some materials.
Excellent. Thanks, Andrea. I'm here just to present our next speaker, Professor Richard Johnston. Professor Johnson is professor in the Griffiths Law School in Queensland, Australia, where he was the Director of Socio-Legal Research Centre from 2003 to early 2010. From August 2001 until April 2004, he was the founding director of the National Research Centre for Occupational Health and Safety Regulation, based in the Regulatory Institutions Network at the Australian National University in Canberra. Since 2007, he has been one of the two co-directors of that centre. Richard's academic research are in regulation, particularly work health and safety regulation, socio-legal research, labor law, and legal education. The title of his paper today is he's going to give us a perspective from the Australian legislation, work, health and safety, and criminal law in Australia. So please join me in welcoming Professor Johnston.
Well, good afternoon, everybody. And before we start, can I thank Catherine and Steve for inviting me to this symposium. I'm very honoured to be here, and I'm particularly pleased to be on the same program as Steve Toombs and Harry Glasbeck, whose work I've admired for a long time. Can I also thank Carolyn, the amazing Carolyn, not only for organising the conference, but for getting me here and for organising my accommodation. And before I start again, can I just pay my respects to all those still affected by the Westray disaster? Oops. Let me begin by just giving you an overview of what I want to talk about today. And I'm afraid both Steve and Harry have said they're not going to talk about the boring bits of law. I'm afraid I will. but I'll try and do it in an interesting and provocative way. I want to begin by explaining the systematic decriminalisation of offences in the Australian Occupational Health and Safety Statutes. In other words, I want to talk briefly about the processes resulting in the ambiguity, conventionalisation, individualisation and decontextualisation of offences in the Occupational Health and Safety Statutes. And for the second part of my talk, which will be the bulk of the talk, I just want to talk about how Australians have tried to respond to that by calling for greater criminalisation. There are two aspects to that. Firstly, the manslaughter debate, which has been unsuccessful but quite interesting in part. And secondly, an attempt to recriminalise the occupational health and safety offences by increasing financial penalties, by enacting new offences where there's some mens rea, or in this case recklessness or negligence involved in the offences, or alternatively offences where contraventions have resulted in serious injury or death. And the third aspect of that argument about recriminalisation is to introduce non-pecuniary sanctions, and I'll talk about those in a moment. The Australian story has to begin in the UK in the 19th century. When the UK Factory Inspectorate was founded around about 1833, initially it adopted a very strong approach to prosecution. If my recollection is right, the early inspectors would prosecute about 1 in 4 contraventions. But soon they adopted an advise and persuade approach where prosecution was the last resort and only used for serious or willful offences. And of all the accounts, the historical accounts, my favourite is by Kit Carson, now a fellow Australian. And Kit points out that this approach was the result of the conflicting forces that the inspectorates faced. At the time, there was strong support for effective health and safety regulation, especially by large urban manufacturers. But when inspectors went out to enforce, they actually found that contravention was widespread. It wasn't by a few bad apples, but it was part of production. And the inspectors' response to this difficulty, or this clash of forces, was to adopt the advise and persuade method and to make sparse use of prosecution. And Carson theorises this, or talks about this, as institutionalising the ambiguity of factory crime. In other words, health and safety crime is not seen to be really criminal. He also talks about how health and safety offences, health and safety provisions are frequently contravened but very rarely enforced in practice, are substantially tolerated, and talks about this as the conventionalisation of health and safety crime. Now, these pressures are exacerbated by the fact that most health and safety offences in the statutes are strict liability or absolute liability offences. They don't require mens rea. And it's also exacerbated by the fact that most of the offences can be committed without any harm actually resulting. In other words, the offence is putting workers at risk. Going to be it. Okay. The next part of the story is the adoption by the Australian jurisdictions of the UK approach, and particularly the enforcement approach. And first, a digression. Australia, since 1901, has been a federation, and for constitutional reasons, which I won't go into, legislative power for health and safety regulation lies with the states and the territories. So we have 9 occupational health and safety, what we call them work health and safety statutes. Now, the Commonwealth has a statute, but it's largely for Commonwealth employees. Now, the Factories Acts, the UK Factories Acts, were adopted in the Australian colonies from 1873, when Victoria first enacted the Factories and Shops Act, and then South Australia in 1894, New South Wales 1896, Queensland 1896, and Western Australia 1904, and Tasmania 1910. I did that just so that you'd know what all the states were. And it's clear that from the outset, the Australian inspectorates adopted the UK advise and persuade approach. And I'll just give you one example from my home state. In 1896, the Queensland Inspectorate reported in its annual report that they sought to secure compliance with the provisions of the Act without having to recommend stronger measures than persuasion. You can't get the approach any clearer than that. And this has been the dominant approach ever since. In other words, Australian jurisdictions, Australian inspectorates have adopted the ambiguity and conventionalisation of factory crime as part of their everyday practice. Now, for the second part of my argument, I just want to draw on some of my own work. When I was a doctoral student, I did my PhD on health and safety prosecutions in Victoria, and that involved looking at 200 prosecutions. And that study found that even though the health and safety legislation, as I said earlier, provided for offences that didn't require an injury or a fatality to take place before there was an offence, in fact, in 87% of cases, prosecutions were brought as a result of an injury or fatality at work. And in other words, prosecutions focused on an event. And the prosecution process itself then splintered the event from its context. And you can see the context as a systematic approach to health and safety or health and safety systems, or you could see it more broadly as the conflictual relations within capitalism. But the point is that the event is drawn out of its context during the prosecution process. And once it's drawn out of its context, and most of the cases I looked at were guilty pleas, so there wasn't much evidence led about the offence itself, then Defence Counsel was able to construct a whole lot of arguments around the event. And not surprisingly, these arguments involved a close scrutiny of the event and involved blame shifting. So again, it won't surprise you that in most cases, counsel argued that in fact workers were careless, that's why the incident took place. Inspector had been there previously and hadn't seen the incident, hadn't seen the hazard, or purchaser supplied a machine without guards, and so on. Secondly, because there was minute scrutiny of the event, what tended to happen was that Defence Counsel could show that this was a freak accident, a one-off event, because of the amazing confluence of circumstances. And the third thing that happened was that the event was pushed into the past. Because it was an event, Defence Counsel could say, well, that may be the case in the past, but now we have a new approach to management, we've got a new management team. You can imagine the range of arguments that were put. And consequently, I argue that one explanation for the low penalties has to do with this event focus and the ease of Defence Counsel being able to argue that the event is far less serious than it appears to be. And I think this explains the low penalties in the Australian jurisdiction. My calculations were that the average penalty was about 20% of the maximum available, but other studies have suggested it's less than that. And the approach is embedded in the form of law because the criminal law used focuses on events committed by individuals with mens rea. And what is really needed, I think, in the health and safety jurisdiction is to rethink the criminal law and the way that it applies to corporations and to health and safety crime. The other effect of prosecution is that it diffuses health and safety as an issue. In other words, the court goes through this elaborate process of prosecution, but the underlying relations that caused the problem in the first place are left untouched. In other words, you could argue that health and safety prosecutions actually have a legitimating role to support the status quo in terms of health and safety. Now, let me talk briefly about the debate in Australia since the 1980s, but focus on the last 4 points. So, since the late 1980s, there's been quite a significant debate in Australia about the sanctions that are required to enforce health and safety statutes. And we've got infringement notices or on-the-spot fines. They're very strong now corporate officer offences with the possibility of imprisonment, and I'm happy to talk about that at question time. We've got a curious animal called enforceable undertakings, which again I'm happy to talk about if you want me to during questions. But there's been a debate about the reform of manslaughter with only one small success, and I'll come to that in a moment. One of the approaches has to be to radically increase the level of the maximum penalties. We've created new offences with additional elements, mens rea, mainly recklessness and gross negligence, or contraventions that result in serious injuries or fatalities, and those are supposed to have higher penalties. And lastly, we've introduced a wider range of sanctions, and I'll work my way through those last 4 points in the rest of the presentation. Okay, so since the 1980s, there's been a significant rethinking of health and safety regulation in Australia, and part of that debate included discussion about the possible reform of the manslaughter provisions. Now, in principle, with the unreformed law, it is possible to bring a manslaughter prosecution against a corporation, a corporate officer, or a manager. It is technically possible. And I've got on the PowerPoint the test for gross negligence manslaughter, which I won't go through in too great a detail, but basically the level of negligence needs to be so excessive that it's regarded to be criminal. I've set out the test on the PowerPoint if you like that kind of thing. There have been a few examples of successful manslaughter prosecutions in Australia, and one, in fact, successful prosecution under the unreformed law against a small two-shareholder company in 1994. That's the Denbo case. It was a plea of guilty. In that case, a truck driver was killed when the truck's brakes failed while the truck driver was taking a shortcut on a construction site down a steep hill. And there was evidence that the brakes were faulty and that the director knew or should have known that. And the argument was that the director at least could have replaced the brakes or required the truck driver to take a safer route. As I said, that resulted in a guilty plea, a fine of $120,000, which was never paid because, surprise, surprise, the company went into liquidation. There's some other examples of manslaughter prosecutions, but they're not against corporations, and there are only a few of them. And again, I'm happy to talk about them in questions. Why are so few manslaughter prosecutions brought? The first, I've got you on the edge of your seats, haven't I, every time I do this? The first is the point that both Harry and Steve have made earlier, that Australian law requires direct liability, the notorious Tesco principle. In other words, you must find an act or an omission performed by someone who's sufficiently senior to be seen as acting as the corporation. In other words, a director, managing director, or a person to whom the director's authority has been delegated. And in a Victorian case in 1995, the Supreme Court decided that neither the plant engineer or the plant manager and safety coordinator or the two employees who had clearly been grossly negligent were acting as the company. Rather, their acts were personal failures to act so as to give effect to the will of the company. And for that reason, the manslaughter prosecution failed. Even prosecuting individual managers or senior supervisory staff is difficult. To prosecute them successfully, the senior manager or the director must owe a civil law duty to the deceased that was grossly breached. And in most cases, the duty is owed by the corporation, not by the individual. Alternatively, the officer must personally procure, direct, or authorize the company to commit the unlawful act, or must assume a personal responsibility to the worker so as to create a special relationship between the two. Now, the only point there is that all of those things are very difficult to show. And even if you do, you then have to show that it was an act, not an omission. And in most cases, in many cases, if not most, that the conduct involves an omission. Okay. How has the Australian jurisdiction, various jurisdictions, attempted to address these difficulties? At the federal level, the Commonwealth level, the Criminal Code Act of 1995 introduced provisions that many people talk about as being the Australian innovation, and I'll talk about it very briefly. These provisions have great potential to alter the Australian law of corporate criminal liability. And basically, they provide that if negligence is a fault element, so in gross negligence manslaughter that I mentioned earlier, negligence is a fault element, that fault element may exist on the part of the body corporate if the body corporate's conduct is negligent when viewed as a whole. That is, by aggregating the conduct of any number of its employees, agents, or officers, not just senior officers or senior employees, but any. It's called the aggregation principle. Then there are other provisions indicating what might constitute negligence, and at the risk of losing you, I'm not going to talk about them, but they're on the PowerPoint. And then if intention, knowledge, or recklessness is an element, and that will be the case if manslaughter requires recklessness, the fault element must be attributed to the body corporate that expressly, tacitly, or impliedly authorised or permitted the commission of the offence. And the authorisation or permission can include reference to corporate culture. So, for example, you can show that that the corporation authorised or permitted an offence by proving that a corporate culture existed which directed, encouraged, or tolerated the non-compliance, or alternatively, that a corporate culture existed that failed to require compliance. Now, that looks quite exciting, although, as Steve pointed out, it has been criticised for being a bit vague. But for me, excitement trumps vagueness. The problem with this is that this is the Commonwealth provision, and in the Commonwealth Act, there is no industrial manslaughter provision. So that means that at Commonwealth level, there isn't the opportunity to bring a prosecution. Only one other jurisdiction has copied this provision, and that's in the Australian Capital Territory. I know how many people there, how many adults there are on the Australian Capital Territory because they had their election on Saturday, and there are 250,000 voters. They're mainly public servants, academics, or retail people who service academics and public servants. The point I'm obviously trying to make is it's not a huge jurisdiction with lots of industry. No other state or the Northern Territory has adopted those provisions. Victoria came fairly close. Victoria came fairly close a few years ago, about 10 years ago. I nearly said it's a few years ago, but time moves fast, doesn't it? About 10 years ago, when it enacted when it debated the Crimes, Workplace Deaths and Serious Injuries Bill in 2001, which also included an aggregation principle. And again, I won't go through the detail there because it's quite boring if I read it out, and I'm very quiet. I'm unlike Harry, I can't entertain you with dynamics in my voice. And again, there were a series of provisions showing how a corporation could be negligent. But these provisions were halted in the Upper House in Victoria, which is a notoriously conservative body. So the upshot is that the attribution principle, the Tesco principle, applies in all jurisdictions except the Commonwealth and the Australian Capital Territory. There has been some reform of the elements of manslaughter. Not in Victoria, this was a failed provision, and I'll come to the other in a moment, but in Victoria there was an attempt in that failed bill to redefine industrial manslaughter and to create a crime of negligently causing serious injury, but that was rejected when the bill disappeared. And in Queensland there was some discussion of a crime of dangerous industrial conduct, but that wasn't ever acted on. And in a moment I'll come to the ACT, which is the only jurisdiction to enact manslaughter provisions. Now, before we leave the Victorian provisions, there was an interesting attempt to create accessorial liability for senior corporate officers. So the Victorian bill provided that if it was proven that a body corporate committed the crime of corporate manslaughter or negligently caused serious injury, a senior officer of that body corporate could also be found liable for an indictable offence if, 1, the senior officer was organisationally responsible for the conduct, second, in performing or failing to perform his or organisational responsibility, the officer contributed materially to the commission of the offence, third, the officer knew that as the consequence of his conduct, there was a substantial risk that the body corporate would engage in conduct that involves a high risk of death or really serious injury. And finally, having regard to the circumstances known to the senior officer, it was unjustifiable to allow the substantial risk to exist. Now, I read those out deliberately because that's quite a number of hurdles to get through, but it was still too challenging for the upper house in Victoria, and they refused to pass that. Now, let me tell you briefly a success story, because I feel that all I've done is contribute further to the woes that we've been talking about this morning. Late in 2003, the Australian Capital Territory, 250,000 adults, don't forget, enacted the Crimes Industrial Manslaughter Amendment Act, which created new offences of industrial manslaughter, both for senior officers and for corporations. So employers could commit industrial manslaughter, and senior officers could, if a worker, which was defined very broadly, people who are interested in the changing labour market and how labour law has addressed the changing labour market, would be impressed with the definition of worker in the Australian Capital Territory manslaughter provisions, includes employees, independent contractors, employees of contractors or subcontractors, outworkers, apprentices, trainees and volunteers. If a worker's, so you could have industrial manslaughter if a worker was employed or engaged by the employer and dies in the course of employment, the employer or senior officer's conduct causes the death, and the employer or senior officer is reckless or negligent in causing that death. Now, by negligent, we mean gross negligence. The maximum fine is $200,000 or 20 years imprisonment. And there's also provision for non-pecuniary penalties, which can amount to, together with a fine of up to no more than $5 million. And I should say the Australian dollar is roughly the same as a Canadian dollar, probably slightly less, unless you change your money at the airport in Sydney, where I was completely thrashed on the exchange rate and haven't really got over it. I'll skip the digression into... Well, let me just tell you briefly about this. There was a very, very bad case of a young girl jumping off a building to her death as a result of serious harassment a few years ago. And she was the cafe, the workers at the cafe at which she was working were prosecuted under the health and safety legislation and received fairly substantial penalties. But such was the public response that the Victorian government modified the stalking law in Victoria to include provisions that would affect the kind of harassment that poor Brodie Panlock was subjected to. I just include that because it is part of our debate, although it is a circuitous route. Okay, I'm going to have to disobey instructions a little because I want to come to my second point, but I can do it quite quickly. Okay, so the other approach is to revive the criminality of the Health and Safety Acts. And Appleby in the UK argued for this in relation to the UK as an alternative to manslaughter. Now, I'm not arguing that it's an alternative to manslaughter. I think the two go together. But the argument here, and this seems to be the argument that the Australian various jurisdictions have adopted, is that we can revive the criminality of the health and safety legislation in a number of ways. The first is to radically increase the maximum penalties. Now, they're on the PowerPoint, so I'm not going to go through them, but let me just tell you that when I started working in this area when I was a student, in about 1980, the maximum penalty in Victoria was $2,000. Now, I know money has devalued since then, but even then, those increased penalties are very significant. So that's the first point. Secondly, you'd think that I would have got this right by now. Secondly, there's been almost a virus in the health and safety statutes over the last 5 or 10 years where legislators have introduced new maximum penalties by creating offences where a contravention of the health and safety legislation results in a fatality or serious injury and where there is negligence or recklessness. So the two examples I've given you there are from New South Wales, where there's an offence when a general duty is contravened which results in a fatality and there's recklessness. And in Victoria, and there in New South Wales, the maximum penalty is just over $1.5 million and a possibility of 5 years imprisonment. And in Victoria, there's a reckless endangerment offence, so it involves recklessness and involves placing another person in danger of serious harm. And there the maximum penalty is just over $1 million and there's a possibility of 5 years imprisonment. Now, I'd love to be able to tell you that I found lots and lots of prosecutions under these provisions. And there are two possible explanations for my only finding one. I won't go into the first, but I'll get a research assistant to check. But the second is that these provisions may not be used very much by the regulator. The one case in Victoria was the Orbit drilling case, where there was again another truck which was not roadworthy, driven by an untrained truck driver down a slope, resulting in a fatality, and there the penalty imposed was $750,000. I'm on to my last two PowerPoints, if I can beg leave to finish. The third point is that in the 2000s, the health and safety statute started including what I call non-financial penalties. And this was largely because of the well-documented criticisms of the fine. In other words, it's easier to pass the cost of the fine on. Often it's unrelated to the ability to pay. And imposing a fine on a company doesn't necessarily require it to do anything different. So many of the jurisdictions, and I've noted them on the PowerPoint, have given courts the power to impose adverse publicity orders, to order companies to engage in OHS-related projects. So, for example, have to develop a code of practice or do research into the particular hazard and so on. Can require the company to, or the defendant to take remedial measures or to undertake training, and finally to adjourn a case with or without conviction, and requiring the defendant to give a undertaking not to reoffend within 2 years, with serious penalties if they do, and also to require the company, the defendant, to engage a consultant, develop systematic health and safety management systems, and so on. Okay. So what have we got now? There's been a small revolution in Australia. There's a Model Act, which was developed, would develop very slowly over a period of time, but the final version seemed to be around about 2010. It's been adopted by just over half the jurisdictions, and a few more recently have lurched towards adopting it. What do we find in it? Firstly, we find that there are 3 levels of penalties for contraventions of the general duties. At the top level, if there's recklessness and anybody is exposed to the risk of death or serious injury or illness, then the maximum penalty is $3 million. And for individuals, and I won't go into the nitty-gritty, between $300,000 and $600,000 or 5 years imprisonment. And then for Category 2 offences which don't involve recklessness, the penalty is half. And then for other offences which don't either involve recklessness or exposure to serious risk, then the penalties are $500,000 for a corporation and $50,000 to $100,000 for individuals. And there are also significant non-financial penalties along the lines of the ones that I spoke about earlier, which have effectively been codified. So let me conclude. Most attempts to reform the law of corporate manslaughter or corporate officer manslaughter have been unsuccessful, apart from the ACT. And so the consequence is that there's little scope for the use of what I will call the mainstream criminal law for symbolic or retributive purposes. And I think those are both really important. But that possibility is not strong in Australia. The focus instead has been to increase sanctions in various ways for the occupational health and safety offences in the Occupational Health and Safety Act, where the focus is on deterrence, very instrumentalist approach. And the problem, I think, with this latter approach is that nothing has been done to address the underlying ideological problem that health and safety law is not regarded as really criminal. Now, we can talk a lot about what we might be able to do about that, but all these changes are taking place in the statute book, and we don't have any public debate about the problem of the decriminalisation of health and safety offences. And I'll stop there. Thank you.
It's the same question that we asked of Steve Toombs this morning, and that is, how is the Australian labour movement involved in promoting prosecutions under the Australian law?
This isn't directly answering your question, but one of the tragedies of the harmonisation process that I spoke about briefly at the end. So the harmonisation process involved a committee getting together and consulting widely, but trying to develop a model act that took the best of the various provisions, used what worked well, and didn't use things that didn't work or that were too controversial. One of the sad consequences was that the union right to prosecute in the New South Wales Act and in the ACT Act was removed. And I think that that's a serious problem for reasons that I think most people can understand. Giving workers a right to initiate prosecutions, and you can limit it by saying, well, this can only be used after the point at which the state has had its go and made a decision not to prosecute. Taking that right away, I think, is a very problematic thing. I haven't done a detailed study on the prosecutions that were conducted in New South Wales. This would be over a 20-year period, but basically there were about 20 prosecutions. They were all extremely important because unions brought prosecutions over things that the regulator was very reluctant to do. Largely over things that had to do with the organisation of work, that had to do with harassment issues. There were 4 cases brought against the banks and I don't know how I don't understand how banks think generally, but I particularly don't understand how they thought in these circumstances, because workers tellers didn't think that they were adequately protected against armed robberies. Now, I would have thought, well, I'm going to make the obvious point that if a bank was going to protect itself against something, it would be an armed robbery. But anyway, as a consequence of the 4 prosecutions, there were significant changes in the system. So that's the first response, is that the labour movement, that right to prosecute has disappeared. Funnily enough, it's still back in the New South Wales Act. Under quite complicated circumstances, a prosecution can be brought for a Category 1 or 2 offence, and then as of right and for the 3rd category. But it would be good to see that across the board. Just keeping my lawyer's hat on, the health and safety representatives, workers representatives have the right to issue provisional improvement notices, which are effectively an improvement notice but issued by a health and safety representative, and have the collective right to stop work, which I think is an important thing. Union representatives are involved in tripartite discussion, in the tripartite Safe Work Australia, and unions are basically pretty strong in arguing for improvements to workers' rights and to prosecution. But for a long time, they were under a Conservative government, the Howard government, where I don't think unions were taken as seriously as they should. So I think there are institutions within the Australian system for worker representation, not as strong as they should be. The real problem is that unionisation is only 19% now. I mean, that's the difficulty with all of this. And we haven't really got civil society institutions that are stepping in to bolster that participation. I think that's from... When I was a kid, I was part of the Workers' Health Action Group in Victoria, which was very exciting. And, you know, we were going to change the government and flip the mode of production over, but we didn't quite get around to that. But you don't have those institutions anymore. I don't know if that's quite answered your question, but I just checked under W in my brain and told you everything I could.
Richard, I just want to bring you back to what you said about OH law not really seen as criminal. And in what we've heard today, there's a huge range of even sentences. In Quebec, the maximum sentence for the violation of an order by an inspector is $3,000 for a corporation. It's higher in the rest of Canada, and obviously it's higher in Australia. But my question is this, is it that the OH law is not really seen as criminal, or is it that workplace deaths are not really seen as potentially criminal contexts or situations? And could you make those nuances and those distinctions?
I think the short answer to the question is both. I started by trying to, I think it's an obvious point in a way, but just trying to illustrate what I mean by decriminalisation. And I think it's a big ideological point, and it has to do with process and procedure as well. But for some reason, deaths at work seem to be as egregious as the kinds of things we read in detective novels. And I think people have been exploring that this morning. A lot of it's got to do with this so-called careless worker thing. But let me tell you my solution to this. And this really is very Cameron-esque because it really doesn't take human rights into account. I think there should be a game show on commercial television. And I am answering your question. And what we should do is show people what happened in the worst fatalities that took place in our jurisdiction. And then we should vote for the top 5 to be prosecuted under manslaughter law. Now, I know why this is not a good thing from a civil liberties perspective. But I think that if people actually saw how serious these things were, that public opinion, which I think is in favour at some level of seeing these things as criminal, people really would see just how criminal. And I'm going to say putting workers at risk. I'm not even going to get as far as talking about fatalities. So it seems to me there's a whole battle to be fought on an ideological level, which would involve some sort of public campaign on television and so on, which was very successfully done in Australia, particularly Victoria, in relation to road traffic. 20, 30 years ago, when I was doing criminal law, we were told that these road offences, dangerous driving, weren't serious offences. Nobody would say that today. That's seen to be serious criminal offences, and we just have never really done that with health and safety crime. So, is that? Yeah. Yep. Take a supplementary if you think I
guess the supplementary question would be, who is we?
Who is?
Who is we? And who is going to do this? And why is it not done?
Well, we clearly can't leave it to regulators. Yeah. Because I just don't think they get it. I think health and safety in some senses has become so technocratic. And in fact, I find myself doing it. If I spend time with inspectors, I find myself thinking like an inspector as well, which is not all a bad thing. But the mindset about this not being really criminal is so deeply entrenched. When I did my PhD work, I actually interviewed a whole lot of magistrates, and each one, unprompted, told me that the health and safety legislation wasn't really criminal. Actually, that's not true. 12 told me that it wasn't really criminal. The 13th told me that these were really social offences. And I don't know what a social offence is. I'm sure we've done many of them in our time, but I don't think health and safety offences are social. So I think we, workers' health action groups, people who care, just trying to get a debate along the lines of the road traffic debate, where you saw commercials. I remember going to movies where the commercials were so excruciating that you'd sink into your seat and block your ears and cover your eyes because it was so confronting, the kinds of things that happen in motor accidents. And, I'm such a happy-go-lucky guy, I think we should have the same thing in cinemas in relation to health and safety.
Merci. Jules Fidel, Université Sherbrooke.
University of Sherbrooke. You were saying earlier that the level of accident hasn't changed after the adoption of the law in 2004 in Australia, with the reforms that have taken place in 2010. Most notably, you proposed new violations and enforcement of the fines and non-financial fines. What are the effects of this new regulation in society? Has it changed the behavior of the worker or of the society of the enterprises?
I'll do my best to answer that. It's a very difficult question. You're basically asking about effectiveness, if I understand the question correctly. There is some evidence in a falling of fatality rates and injury rates in Australia. I always regard these things very skeptically when they're official statistics, and it's very difficult to do your own research on it. I think the Australian government in 2002 set itself the target of having the lowest level of traumatic work-related fatalities in the world by 2009, and at about 2007 said, well, we're not going to get there. I think at the moment we're about 7th, and I'm embarrassed to say, because of traditional rivalries, that we're actually worse than the UK. And of course we're behind all the Scandinavian countries. But there is, if you look at the data, there is a trending down of both injury levels and fatality levels. But I'm very skeptical, because those are largely based on workers' compensation statistics. Every now and then we have some attempts to come up with a robust figure drawing on other sources. It seems to me that people do know more about health and safety, do understand it better. But I don't necessarily think that that means that health and safety performance is better, because the world of work is more complex now. And as work arrangements become more fragmented, issues to do with coordination of work result in health and safety issues and so on. So there's certainly, one of my favourite films is Fantastic Mr. Fox, and at one point little Fox asks the coach if he's getting better, and the coach says, well, you're sure as Cass ain't getting any worse. And I think certainly Australia is not getting any worse, but I don't think it's progressing as quickly and as well as it should. But it'd be interesting to see what the harmonised legislation does actually make a really strong attempt to deal with the precarious and contingent work scenarios. So there may be improvements. But so the short answer is that statistics say that they're small improvements. But I'm pinching salt as I say that.
Great. Well, join me in thanking Professor Johnson for his presentation. So now I guess we have a very quick change over to the next panel, which is on the challenges of prosecuting corporations, prosecutorial perspectives. Thanks again.
Oh, okay. I'm okay not being on the camera, but still speak. All right, so my name's Nina Hansen, and I'm from the BC Federation of Labor, and incidentally, I'm also a steelworker. I've been asked to chair the prosecutors panel today, and very pleased to do so. And also very pleased to announce that we actually do have one prosecutor on the panel, Sean Brennan from the Manitoba Crown Prosecutor's Office, which is fantastic. And I will say just, I'll give a plug to Quebec because I understand that the Quebec Crown Prosecutor was invited and was very excited to come but was unable to do so due to his work duties. Also with us today is Vern Edwards from the Ontario Federation of Labor and Corey Willard, who is in the middle here as a law student to tell us about his work on this issue, which is fantastic. So I was also asked just to give a bit of a brief sort of update on what's happening in BC. As you can see, there's no BC Crown Prosecutor here. And that was not because they weren't invited. They certainly were, and gave us a number of excuses. First one being that they had a moratorium on flights. And so the organizers very generously offered to pay for their flights and accommodations, and surprisingly, there was another excuse offered instead. So Steve Hunt was up here earlier this morning and talked a bit about the Weyerhaeuser case, which I would say is obviously the most sort of egregious example that we have in BC of gross corporate negligence not being held accountable. But we have a lot of other cases. And the reason why I'm getting a bit emotional is because I'm actually been working with the families in these other cases, and it's really disturbing actually in BC how these cases are not going to trial and they're not being convicted, these employers in these terrible cases. One case, there was actually 33 criminal charges that were recommended by the RCMP, and it was actually pled down to a minor offense of, and $2,000 fine was levied. So as you can see, it's not going so well. So what we have been doing is making some really comprehensive presentations along with the steelworkers to the government. And so far lately in this year, they've been giving us a bit of lip service because we do have an election coming up in 2013. And what we told them is that, well, we wanted a dedicated prosecutor. And they said, well, guess what? You have one. So they told us that we have a dedicated prosecutor who is an expert on health and safety, and shockingly, he is the same prosecutor who has been the prosecutor in all these cases that we've had in BC. One where I actually sat in the sentencing hearing and listened to him give a very effective presentation on the defense's behalf, I would say. And the defense lawyer basically got up and said, yeah, what he said. And essentially begged the judge to be lenient and be very lenient with the fine that they were going to levy as well. Of course, no jail time was recommended at all. So very shocking. Anyway, I will pass that off now to Vern, who I see is pouring some water. But Vern first, I would say, to give the Ontario perspective, and then perhaps Sean to tell us a bit about how Manitoba managed to get to the table today.
Okay, so our experience in Ontario, and maybe I should provide some background for our international guests. The criminal code is a national statute. It applies to all jurisdictions across the country, but that it's up to each provincial and territorial jurisdiction to then apply it. And in Ontario, we have two ministries. One ministry, which used to be the old Solicitor General, is now called the Community Safety and Correctional Services, has a responsibility, sort of an overall responsibility around police forces, each police force, of course, being an independent employer. And then we have the Ministry of the Attorney General, which is responsible for Crown attorneys and providing training for Crowns and advice to Crowns, et cetera, et cetera. So from the time C-45 had actually come into effect in law in 2004 and up until December of 2009, We saw a couple of cases where charges were laid and then dropped, and we started to ask why. And we tried to get meetings with with both ministries, each of the ministers, and they just flatly refused to meet with us. We started digging for information. We were able to get some information out of the Ministry of Community Safety Correctional Services. And apparently the day before C-45 came into effect, they sent to every chief of police in Ontario a memo talking about Bill C-45 and what that amendment to the criminal code was about. There was a plain language guide that the federal government produced, and it's available in both French and English. And then there was the bill itself as it was passed in the House of Commons. So that we were able to get from that ministry. And that seems to be as much information as that went out, and that was it. And we would hear from our affiliates, there was another tragedy, and the police have gone in and they've ruled out foul play. They do some work in terms of the coroner, because there might be a coroner's inquest called, but then they basically turn it over to the Ministry of Labor and see you later. So that's the kind of information we were getting back, and so every time we'd get a different minister, there'd be a change. We'd try to get a meeting, and again, we'd get turned down. And that's basically where we were at until December 24th of 2009, when a number of workers at the end of their shift, tragically, they're up on the 13th floor outside of the building, and the swing stage they were on broke in two, and a number of them fell. 4 were killed, and 1 was very badly injured. And from that, our president of our federation, Sid Ryan, who's been a long-time health and safety activist, was rightly outraged that so many workers would be killed like that, and launched a Kill a Worker, Go to Jail campaign, and say, okay, well, what is this going to consist of? So one of our staff had been working with the Toronto Police in terms of race relations, and was able to get a contact with the lead detective. And I contacted him and sent him some information, and he seemed really appreciative about getting that information and our interest in trying to assist and trying to help with this horrific tragedy. And he's actually on a panel a little bit later. So we decided, well, that went well. And if we're getting a C-45 investigation in that case, maybe this is what we should be doing. And so from that time forward, every time we heard of a worker dying in the workplace, I would track down, well, what police force has jurisdiction? We can send a letter to the chief of police. We've got that package of information that went out to the police, every chief of police back in 2004. We'll send them that information, and that's what we started doing. And I would drill down, if it was a larger police force and they had multiple divisions, okay, where did that tragedy, which division was it, who's the superintendent in charge, send it to them, provided them with information. Kevin Sador is the detective I'm talking about. I got his approval to send his contact information to other police services and say, look, you want to talk to somebody who's already done this, here's his contact information, you can call him, and he'll help you in that case. So we've been doing that since basically 2010. Every time we hear about one, we have to rely on the media, basically. There's about 70 workers traumatically killed in Ontario every year. We hear of 6, 7 maybe. So we're still trying to get that information, but we get that out there. We did manage to get a meeting finally with the Attorney General after that tragedy, and we were asking about training of crowns, and he basically kept saying the police are independent, the police are independent, the police are independent, yes, but what about the crowns? We would like to see more training for crowns. What kind of opportunities are there to train crown attorneys? Because we know the police are independent, but they go to the crowns for advice sometimes. What kind of training are you doing? And we couldn't get an answer, but they promised that they would look for training opportunities for crowns so that they would be better educated around those amendments to the criminal code. Still, the Ministry of Community Safety and Correctional Service refused to meet with us. They have refused to meet with us to this day. The minister has. We have met with folks in their criminal law policy branch. who also have some responsibility in terms of Crown and advice to Crowns, and they assured us that yes, they do have some online material for Crown attorneys, but it's considered advice to a Crown, and it's not something they can share. It's not something that even defense attorneys get, so it's advice to Crowns, and it's confidential. So again, encouraging them to maybe provide more workshops for their Crowns. And we talked about the 20th anniversary of Westray coming up, and use that as a basis for additional training of Crowns. And then they restructured, and our main contact went out the door. And so now I'm starting all over again, and I've made contact again with the new person in there who seems interested in looking at doing something maybe in May in terms of additional training. But certainly with the case of Metron here, which was the company where those 4 workers were killed Christmas Eve, that company pled guilty. They were sentenced $200,000 fine. That is currently under appeal by the Crown. But there's also a case out there in terms of the project manager, criminal charges pending, and that's in preliminary hearing. So that's why, or at least that's the reason why there's nobody from Ontario out of the Attorney General's office here. Is they're very nervous about talking about this issue because there's the appeal, and there is a case before the courts right now. So it's not like the organizers here didn't try to get somebody there. They did, and they asked me to try to intervene and try to talk to get somebody in, and I've done that both in terms of the deputy minister level and at the criminal law policy branch, and asked them, even if they won't come and speak, at least send somebody to be here to listen to the presentations today. But I don't know if that actually happened. But so these are the kinds of things we're doing in trying to get more education for Crowns and for the police. We took the opportunity last year to write to every chief of police ourselves, talk about the day of mourning, the importance of every workplace death being investigated through the lens of C-45. This year, we wrote to police associations. I tracked down the presidents of 25 police associations, wrote to them and asked them, union to union, please help us protect our members by making sure your members are trained in C-45. So those are the kinds of things that we're doing. What I really see that it's going to be a real struggle to change the mindset within the justice system in terms of prosecutions, because it's very individual responsibility, and it doesn't seem to be, willful blindness doesn't seem to be enough to get prosecution. So I think part of the problem is we're going to have to continue to struggle to get Crown attorneys and police educated around corporate responsibility in terms of workplace fatalities.
Great, thanks, Vern. So, Sean, maybe you can tell us a bit more about your role and what's happening in Manitoba.
Thank you. My name is Sean Brennan. I'm a senior Crown attorney with Manitoba Justice Prosecution Service. You'll see in your agenda for today that I'm listed as the dedicated prosecutor for workplace safety and health. Yes and no. I think one of the lawyers said it depends is the classic lawyer answer. I'm in a unit called Special Prosecutions. Half of my unit does white-collar crime, and the other half, at least notionally, 3 of us, do all provincial statutes across the province. Animal care, tax, hunting, fishing, environment, workplace safety and health, you name it. I'm one of those 3, and I'm quite often alone in my unit. I do a full panoply of criminal prosecutions as well. So really, when it is said that I'm the dedicated prosecutor for workplace safety and health, yes, I am the guy in Manitoba that does that work, but it is not all of the work that I do. So I think that's an important thing to say. A couple other important things that I wanted to say is, as a frontline Crown, the hardest thing that I do is meet with the next of kin on workplace fatalities, and I always start my discussions with them on a very personal level, indicating how sorry I am for their loss, and I think that it's important for us to focus on that as we sit here 20 years after the Westray mine disaster. The other thing I would observe is, in terms of training for Crowns, part of me feels like I'm in an enviable position when I hear about some challenges from different parts of the country, until I reflect on the fact that I've been in this unit for 12 years, and this is the first conference I've been able to attend, despite annual requests. Even getting textbooks is a matter of stealing and begging and having the Department of Labor pay for them. One of the chief difficulties that I've observed as a statutes prosecutor is that there is a, I don't want to say animus, but there is a struggle within all provincial statutes to have courts, sometimes, but not always, police, and sometimes my management and colleagues to take the offenses as seriously as they should be. And I have to say, after having done it for 12 years, I feel a great deal of ownership in, most notably, of course, workplace safety and health, but also a couple of other areas of provincial statute prosecution. In Manitoba, there are a couple of distinguishing factors that are not present, obviously just distinguishing, in terms of our context. As Professor Glasby pointed out, by extension, I'll extend his thoughts, we do not have, for the most part, these huge corporations with diffuse shareholders, and we deal largely with small to medium, even by Manitoba standard, offenders. And I think that that's something that's important to recognize in terms of the comments I'll be making later. The other thing is that our volumes are less than a tenth, I'm gonna suggest, what Ontario is. So when you hear me painting a rosy picture about how Justice is partnering with Manitoba Labour and we're progressing really well on a number of fronts, keep in mind that we're not fighting the same battle in terms of numbers that are going on across the country.
Great, thanks, John. Corey, did you want to?
Okay, well, I'm not a prosecutor and I will never be a prosecutor. Actually, I'm an articling student. I was a law student last year, and it's an issue that interests me a lot. It was a question I asked to a professor who is here in the room today in second year, and it just snowballed from there because we weren't able to find an answer, and we're still not able to find an answer. So my view on how prosecutors should be dealing with it, last year when I went to the CLC symposium, I thought really we have to focus on police because it's not very complicated. We've all seen movies and we know how a criminal procedure works. We have a crime, we have an investigation, police take over the investigation, then we look up to the Crown's office and find out if we can continue. And then there's other steps along the way, but that's pretty much how the process works. And police and Crown work together, or they should be working together in the ideal society. So what I've come to realize is that it's extremely difficult to get any information from Crown prosecutors. As a future lawyer, I can understand that they are bound to privilege and they're bound to confidentiality. However, there needs, if they can give answers out to the public, then there has to be a communication and the approach has to be organized. So what Vern recently said was the approach to Ontario is trying to have an organized approach to dealing with this problem. And I think that's the only way that we'll be able to really find out what's wrong, why hasn't there been prosecutions under C-45. Personally, I don't think anyone in this room has an issue with that there hasn't been any prosecutions under C-45. It'd be great. It would mean that every corporation in Canada has been not due diligent or not criminally responsible. However, we don't have an answer to why there haven't been all these criminal prosecutions. So I think that's what we really need to find is why hasn't there been? If we could get an answer as the Crown prosecutors don't feel that they can continue, then that's an answer, and then we can find out what factors are considered, because it is a unique type of situation. I mean, It's not like if it's a criminal code amendment to a crime that's been tried before the courts a lot, there are very little precedents, and as if anyone has read the decision from the Metron case, the judge has stated that there was very, very little precedent. So I think it's clear out there, but there needs to be that minority, and I think as individuals here today, we are a minority who wants this to go forward, and we need to find the Crown prosecutors. We've identified the police officers, at least in Ontario, who are willing to push and who have pushed extremely hard, have dedicated their lives to that, and we will hear from them later on this afternoon. But now it's up to us to find these Crown prosecutors who are willing to move forward. I know there's one that was in Quebec who did the Scroca case. His name was François Allard, worked extremely hard on that case and got a guilty. So that's how I look at it. And I truly believe we're at the step of finding out what's wrong. Why aren't we? I mean, the Weyerhaeuser. Why hasn't this moved forward?
Yeah, thanks, Corey. Which is a perfect segue into my next question for Sean. So, Sean, what do you think are the factors that need to be considered when determining whether to proceed with the Westray Bill charges, and then also the follow-up, as in what are the challenges in proceeding once you get there?
That's a good question. I think I'd like to orient you into Manitoba's procedure as a means of going into that. Largely, almost exclusively, reports of significant incidents come from Workplace Safety and Health, the provincial department, the provincial branch within the Department of Family Services and Labor. We get almost no cases referred to us directly by police, and in the cases where we have, they have been not treated in the same meticulous detail and care that I would be accustomed to from the Safety and Health Special Investigations Unit. I would suggest to you as well that criminal negligence caused death or criminal negligence caused bodily harm are among the toughest cases to prove. The cases are largely coming out of driving cases, which have really informed the law in that regard. I would suggest that the marked departure standard and the momentary lapse doctrine wouldn't come out of any other context but driving. The cases also suggest, and I think quite rightly so, that especially when you think of the prevalence of driving cases within the CrimNeg area, that there is a spectrum of negligence. The Supreme Court of Canada has instructed us that there is a spectrum of negligence, and when you think about a motor vehicle accident where someone is killed, it could be that someone has blown a stop sign. It could be that they're speeding and lose control. There could be any number of base offenses under the Highway Traffic Act that could potentially result in prosecution for criminal negligence. Moreover, there are a number of escalating charges under the Highway Traffic Act, such as imprudent, careless. There's a number of them. But on this spectrum, the furthest along is criminal negligence. And one of the things that I look to in assessing whether or not charges should be laid under the criminal code is what's the degree of negligence that's at work in the case before me. And I think that is the absolute first step. The other things that I consider are obviously, is there something over and above what we normally prosecute for under the provincial legislation? In Manitoba, in the provincial prosecutions area, we have had a number of cases, a number of areas where cases have been focused. And we've worked really, really hard in the areas of significant prevalence, that is in guarding and fall protection. And we're really seeing quite a substantial change in terms of guarding, and those cases are going down quite a bit. In terms of what fits under the provincial statute, I think that if someone had a guarding accident and it cost them their life instead of a few fingers, it would be a very difficult decision whether to go under the criminal code or to remain under the workplace safety and health regime, where there are very specific regulations dealing with protection of workers from moving parts of machinery. I think the other thing that you have to keep in mind while deaths are, of workers are an unspeakable sadness, legally, to me, they're an aggravating factor on sentence, okay? It's not something that I have to prove. It's not something that just because someone's dead means there's this huge amount of negligence. It is what it is to a frontline Crown. The challenges are interesting because there are some significant legal distinctions between proceeding under a provincial statute or the criminal code. And let's leave aside marked departure and momentary lapse. Sometimes it's easier to investigate, and I don't want to steal any thunder from the police panel. Sometimes it's easier to walk in as a provincial inspector and compel documents and compel statements and do things that police cannot, and this was alluded to earlier. That's obviously a challenge if you're going to be looking at the workplace death as a possible C-45 prosecution from the outset. I think that's ill-advised tactically. I think that when you're dealing with crime neg cause death, or if the crime neg cause bodily harm, or the Crown is preceded by indictment, there's going to be further delays in adjudication. Accused will be entitled to preliminary hearing, go through assignment court, and await trial in a superior court. The delays are bad enough as it is without adding those additional procedural steps. There are differences in sentencing principles that I think we're going to discover is at the heart of the distinction between Metron and some of the regulatory offenses that far outweigh, in terms of the amount of fines, the decision in that case. Criminal Code in Section 718 has a number of provisions that are mandatory for a judge to consider, and it's very different than the considerations that are mandated for a judge to consider in the regulatory context. After the considerations given, ability to pay is another area where there are challenges. Under the Criminal Code, the judge is obligated to make inquiries into ability to pay. Under a regulatory statute, the law is that general deterrence, the paramountcy of general deterrence, cannot be blunted by inability to pay, and time to pay is the judge's remedy in the imposition of substantial fines. So legally there are many challenges: resource limitations from prosecutions, training deficits from prosecutions, and sentencing principles are certainly among them.
Great. Is there any comments from?
I might just have one thing to add. I did consultation with a bunch of different Crowns from across Canada, and I remember, well, I know one Crown who talked to me about the fact that he didn't understand, who's a very, very senior Crown, who he couldn't understand why would someone want to prosecute a corporation criminally. It did not make sense to him. He said, we've got people out there committing crimes with guns, and why would I be wasting, and they do have limited resources, totally understood, but he just couldn't get his head around that. And I think that's one of the challenges that goes along with when the decision comes, is deciding, okay, well, does it really make sense that we focus on an issue that we have trouble understanding morally? It's not the mainstream crime that we alluded earlier. So that's, I think that's one thing I would add.
Great. Do you have anything to add, Vern?
Well, just in Ontario, I mean, the rules are similar to Manitoba. I think that under the provincial statute, there is no requirement for the judge to take into consideration the ability to pay or what the impact is going to be. I mean, under the criminal code, you've got that section there. And then you've also got the requirement where the judge needs to consider the impact of the fine on the economic viability and continued employment of the workers. And that was some of the rationale in the $200,000 fine that came down against Metron, the company where there was 4 workers killed. So you get a $200,000 fine in that case, a $100,000 fine in Transpave in Quebec. And I think in the provincial jurisdictions on our health and safety, we see much higher fines for single fatalities than we do for, we have so far seen under C-45. So certainly the outcome of even the successful prosecutions have been disappointing, at least from Labor's perspective. I mean, that's the basis of the appeal, that the sentencing for Metron has been appealed. And the Crown has argued that the judge did not apply those assessments properly in terms of the application of those provisions. So the Crown is appealing the $200,000 fine. We'll see where that goes.
I would like to make one comment about the mindset of prosecutors, a comment made by my colleague up here. When you work in a system that is overburdened, and when there are challenges with resource limitations and an extraordinary number of cases flowing through the system, it is hard to improve when you're trying to keep the wheels on. The idea of prevalence, having something taken seriously, I am not so young that I can't remember when drunk driving was regarded as not a serious offense. Well, in Manitoba, there are some 5,000 cases a year of drunk driving, and it's one of the single largest types of cases in our province. And it gobbles up an absolute ton of court and Crown resources. In Manitoba, there are between 10 and 15 provincial prosecutions a year under the Workplace Safety and Health Act on average. And simple arithmetic is going to tell you where the bulk of resources are going to go. And just to not put too fine a point on it, there are a number of cases, of course, in the drunk driving context that result in death. And when we look at the statistics involving deaths of workers, I note that on their own, they're absolutely appalling, but we've never been given any context in terms of where they sit among the panoply of offenses that occur in this country that the courts are concerned with. And I think that that's unfair.
Yeah, and I guess I have a comment from BC just because, I mean, with all due respect, where we've seen BC's resources go are, for example, with respect to prosecuting the offenders in the Vancouver riot. And, you know, not to say that there's, you know, that there isn't something terribly wrong with the riot and that those people shouldn't be punished. On the other hand, the amount of time and resources that is put into this, which was essentially mostly destruction of property, is shocking to us in comparison to things like West Ray and, like I said, some of these other tragic cases where multiple people have died or have had serious life-changing injuries, and yet the case is stayed, you know, or it's pled down to a minor charge, and we're told this is because, you know, they don't have the resources or there's no substantial chance of conviction. Well, they didn't even try. I guess that would be my point. Somebody's got to try, and at least from BC's perspective. So I think we're actually at time's end here. So Andrea?
So I have to be honest, this is an absolutely amazing panel, and as conference organizers, we were nice and gave you guys a break in the middle of the afternoon. But it's in the schedule as a 15-minute break, but I'm going to propose that we just take 10. It's 1/4 now. We come back at 3:25 so that they have the chance to do maybe another question, but would definitely have a chance to ask some questions and talk amongst ourselves and just spend a little more time thinking about what's been raised here and what is a riveting panel of 4 people that I really like a lot. So 10 minutes, and I'm not going to lie, if you come back late, I'll call you out by name. So it's 1/4 now, and we'll see you at 3:25.